Assalamu alaikum and hello to the Ramadan podcast series 2023 of DWMCC, the World Muslim Communities Council, chaired by His Excellency Ali Rashid Al Noaimi. This year's topic of the series is Peace and Prosperity of Muslim Communities in the Changing World Order. My name is Michael Amin Kramer from Austria. I'm a jurist and political scientist at the universities of Graz and Vienna, with a focus on the sociology of law concerning Islam in Austria, respectively Europe. As a member of DWMCC, I'm very honored and grateful for the opportunity today to welcome my distinguished guest, Professor Emilia Justyna Powell from the University of Notre Dame in Indiana, USA. Hello, Emilia. Good to have you here.
Good morning and hello. Thank you very much, Michael.
Dear Emilia, thank you for your time talking about your book, Islamic Law and International Law, Peaceful Resolution of Disputes, published by Oxford University Press in 2020. With the book, Emilia won 2022 the Best Book Award from the International Studies Association in the International Law section, but as well as in the Religion and International Relations section. But before we talk about your book, Emilia, let me introduce you to our audience. Emilia is a professor of political science with a concurrent appointment at the law school at the University of Notre Dame in Vienna. She did her PhD at the Florida State University about conflict, cooperation, and legal systems of the world. She has held several academic visitorships at Oxford Center for Islamic Studies in the UK and a fellowship at Durham University. She is specialized in international law, international courts and international dispute resolution, as well as the Islamic legal tradition, Islamic international law, and Islamic constitutionalism. Her astonishing career and further information can be found on her homepage as well as on the university homepage, www.emiliapowell.com. Dear Emilia, in this regard, as I read your CV, and it's definitely fascinating, I would like to ask you a rather personal question, if this is okay, because I read in your CV and I wondered what happened around the year 2010 when you decided to focus on Islam and Islamic law next to all the other topics you're researching in.
Thank you very much, Michael, for a beautiful introduction, and I really appreciate you hosting me here. To answer your question, I studied law for many years in Europe, and when I was doing my PhD in political science at Florida State University, I focused in my dissertation on how different domestic legal traditions, so civil law, common law, and Islamic law, shape countries' perspectives towards international law. And that was the topic of my first book. And I knew quite a lot about civil legal tradition, being a civil lawyer. I learned a lot about common law, but I really didn't know a lot about the Islamic legal tradition. And I started to read, and I realized that this legal tradition has not received nearly enough of scholarly attention, especially in the English language. And many people conflate Islamic faith with Islamic law and don't focus on the fact that it is, and it has been historically, an elaborate legal tradition. And we need to understand how countries representing the Islamic legal tradition view international law. So I started to read and read and read. And as I always tell all of my students and friends in the policy-making world as well as scholarly world, Islamic law chose me. It means that I have become fascinated because it is a fascinating topic. And the more I read, the more I wanted to read, and the more I wanted to travel and learn from scholars of Islamic law about the Islamic legal tradition. Then I started writing about it. And the more I wrote, the more I wanted to write. So it was a diffusion of my interest into the Islamic legal tradition.
Wow, thank you. Yes, we see that in your book, definitely, that there's so many details. And now speaking about your awarded book, you deal in general with two legal systems. First, the international law, tracing back to the Roman law and the influence of Christianity, respectively the Catholic Church. And second, the Islamic law, tracing back to the role also of the Prophet Muhammad, right? And the Islamic jurisprudence that can be found in a third category. You call it Islamic law states. So meaning the Islamic legal system with Islamic jurisprudence inside. You specify your research objective to peaceful resolution of international disputes. So the question I want to ask is, where exactly did you see the problems for starting your research with these research topics, and what is your book meant to be and what is not meant to be?
That's an excellent question again, Michael. Thank you very much for asking this. The main issue that I wanted to address in the book is a huge misperception in the policy world as well as scholarly world about Islamic law, in that most people believe or trust that Islamic legal tradition is completely contradictory to international law. And that is not correct. That is not correct. And I have not found a holistic treatment of this topic in the scholarly literature that goes in the details of that relationship. Secondly, my book was meant to shed light on the diversity of Islamic law states, as I call them, because again, the popular perception is that all countries representing Islamic legal tradition are for the most part identical, and therefore all of their legal systems will be somewhat contradictory to international law. And again, that is false. And when we consider those two goals of my book, the fact that Islamic law and international law have indeed a lot in common, and secondly, that there is a spectrum of Islamic law states, the relationship between international law and Islamic legal tradition is a really complicated area that the book was meant to address. The book was not meant to be a comprehensive statement about Islamic legal tradition. I am not an Sharia scholar. My interest is mainly in how the Islamic legal tradition focuses on peaceful dispute resolution. Neither do I consider the book to be a comprehensive final statement of the topic. So I make it explicit in the book that I am doing the best I can with the knowledge I have, but we hopefully can all benefit with understanding the relationship between Islam and international law.
Okay, thank you. Definitely, we will speak a little bit later again about the key findings as well, and the similarities and differences about Islamic law, in the Islamic international law and the international law per se, from the international institutions like the ICJ, the International Court of Justice, or the International Criminal Court. But before we do that, I'm interested in your research design. How does the methodology, for example, of your research look like? I mean, how many persons did you interview? What roles did they have, these interview partners, and how difficult was it for you to get in touch and speak with probably mainly male Muslim authorities like qadis, ministers, and other authorities of this kind of ILS, Islamic law states?
Thank you very much. So I believe in mixed methodology. What it means that even though I want to identify patterns of Islamic law states' behavior vis-a-vis international law, and that requires a big data gathering, I also wanted to hear from people. Because as political scientists, I'm afraid that sometimes we love to look at patterns, love to identify large trends based on data sets, but we forget that really those trends are made by individuals. And I did not want to fall in this category. So I have definitely interviewed many individuals. I don't really remember the number. I just know there were numerous individuals from Islamic law states. So these would be policymakers, scholars of Islamic law, religious authorities. From the international forum, I interviewed judges and arbitrators of international courts and international tribunals. I interviewed also Western policymakers because I wanted to hear not only how the Islamic world feels toward international law, but I wanted also to hear how practitioners of international law view representatives from Islamic law states, and how do they view, or if they understand, the Islamic legal tradition. How difficult was it to get in touch with the Muslim scholars and policymakers? I started from the ground. So I would send an email, and more often than not, I received a very positive answer of excitement and appreciation that a professor from United States, that's a female, is trying to look at the Islamic legal tradition and introduce the concept to the scholarly community. So I would say it was not difficult. I was always very welcomed. I have never felt out of place, and I have never experienced any form of gender inequality in the places that I've interviewed or in the places that I've traveled. Some of the interviews, especially in localities that perhaps favor male presence with a female, I would take my father with me. My father, who lives in Poland, would join me in an Islamic law state of our choice and of my choice, and we would go for the interview. Sometimes my husband would go with me, although he was most of the time taking care of my very small child. So it was a fantastic experience. Of course, I abide by the local customs and traditions because I believe that being respectful and being appreciative of each other is the first step to dialogue.
Yeah, definitely. Respect and a form of friendliness, right? It always helps. You said multi-mixed method, and if I remember, in chapter 2, you have some graphs inside where you analyze documents, right, from 1945 to 2012. Can you say something about that as well? Because this, for me, is part of your multi-mixed method, and this was highly interesting for me.
Thank you. Yes, I believe that in order to understand the Islamic law state's attitude towards international law, we need to consider, in the context of each of those countries, the balance between secular law and Islamic law in the context of constitutions of those countries, as well as their sub-constitutional legal system, which are institutions such as courts, parliaments, and other forms of legislation. So, for instance, I analyzed almost 200 constitutions and constitutional amendments of Islamic law states since Second World War till early 2000s, and look for presence of secular courts. I looked for whether women can serve as judges, for instance, in those countries. I looked at constitutions, whether constitution mentions holy oath to God, whether the leader of the country has to be Muslim, how many times Sharia or Islam are mentioned in the constitution. And it gave me a nice comprehensive view of, over time, as well as across countries, differences between Islamic law states. Because really, when we look at any Islamic law state, let's say such as Kuwait or United Arab Emirates, Malaysia, and so forth, there is always a negotiation going on between secular institutions and Islamic institutions across time. And if we can trace these negotiations in law, we really can see how the relationship between Islamic law and international law changes.
Okay, thank you. Because you deal in chapter 3, then afterwards you present these graphs, and this is the question already: what are similarities and differences between Islamic law and international law? So you mentioned, can women be judges? Is the holy oath a part of both systems? In international law, probably not so much, but also about the Muslim leaders, for example, which is, or doesn't matter now in international law. But can you give us a short overview? Where can we find the similarities between Islamic law and international law? Well known that, of course, I think it was 30 ILS, Islamic law states you analyzed, that there is a huge variety in this one. But what would you say in general? What are the points where we can focus and say there is a tendency of similarity that might provide a understanding how secular and religious law comes together or work together somehow?
Right, yes. So I'll start with differences maybe, and differences are normally the focus of the scholarship or the policymaker. We really don't talk about similarities. People have in the past really focused on the differences. So really, when we can contextualize the broad relationship between law and religion, international law is supposedly secular. There is no religious affiliations requirements for judges. They're supposed to be of high moral character, but it's not linked to any particular faith. Now, of course, we have to keep in mind that international law, its history, it's largely rooted in the Christian faith. And we know that. But at the present time, the sources of international law, despite their rootedness in Christianity, are secular. The Islamic legal tradition, on the other hand, we have this intricate relationship between religion and faith, where in some areas it's really difficult to disentangle the two. So the basic premise of the Islamic legal tradition, with God being sovereign and God being the ultimate lawmaker and Sharia being the path to righteousness, is a different philosophy of law that overarches the relationship between a human and law. And from this broad divergence, we can say that there are different sources of law, of Islamic law and international law, because international law, of course, will not have any religious sources, even though the substance of international law, again, kind of is rooted in the Christian understanding of treaties, of pacta sunt servanda, the principle of all kinds of things. In Islamic law, of course, the Quran and Sunnah of the Prophet are also sources for Islamic international law. So therefore, I would say that Islamic law states they can socialize to some parts, large swaths of international law, in fact, but the socialization is limited because of some of the precepts of the Quran and Sunnah. And we all know about the differences across several substantive areas, such as perhaps human rights or criminal law, where we see a bit more tension between Islam and international law. But similarities are overwhelming between Islamic law and international law. And unfortunately, similarities have not been the focus of the scholarly inquiry or discussions in the policy making. For instance, in international law, as well as international law, we have a huge role of scholars in law formation. In international law, scholars like Grotius, Pufendorf, and others, they really generated so many rules that we respect in international law. As we know, in the Islamic legal tradition, we have an amazing focus on scholars. Fiqh constitutes part of Sharia. It is an elaborate system of norms and rules that shape the flow of applications and interpretation of the sources, textual sources of Islam. Custom plays a huge role in international law as well as Islamic law. When we think about urf or other expressions of Islamic custom, we know that as long as it is not contrary to Sharia, it becomes part of Sharia. Well, in international law, custom is one of the sources of international law. So I think this is an important similarity that we can hone in on to make the world a peaceful place. I would want to say also that rule of law, classical Islamic law, and again, I'm trying to separate politics from the precepts of the Islamic legal tradition. So in Islamic law, we have huge respect for rule of law, for the judiciary, for the judicial process, judicial independence. The same is true in international law. So again, if we continue being aware of the differences, but highlight the areas of convergence, we can see a lot of potential dialogue going on. And this is the area that we should focus on.
That's very interesting, very, very impressive. I wonder, because you said, of course, we need to distinguish between the legal tradition of ILS and the politics, because probably this is the clue in it when most probably the Western world sees Islamic law as somehow old or pre-modern or whatsoever. And I think one of the problems could be this nationalism or nationalistic spells. I think you also write about it. Is it justified to say that ILS, in using their Islamic legal traditions, is not as Islamic as the Sharia looks like? And Sharia, in this sense, you write, it's a moral code, and you use a lot of literature to confirm that saying. It's a moral code. So is this politics now the problem of ILS, which is not in line with Islamic legal tradition? Can we say that?
You know, I'm always very careful and honest that it is not my job to evaluate how a country, whether or not a country is Islamic enough, or what's the interpretation of Islamic law, because this is not my place to create judgments about how Islamic or not Islamic a place is. But what we do know, that there is definitely an interaction between strategy, politics, and Islam going on at the state level. So Islamic law states they have to navigate this balance between their commitment to Islam as a legal tradition and the demands of running a country, the demands of accepting, in a way, Western rules in international law. And that balance is very hard to strike because, as we know, so much in the Islamic legal tradition goes back to interpretation. And we can take a norm and see how it is interpreted in divergent way across Islamic law states. Does it mean that one Islamic law state is less Islamic than others? Not necessarily. This is their way of navigating their balance between secularism and Islam. Now, of course, we know that there is a very high tension in some Islamic law states between, let's say, rule of law and performance of the state. And again, that relationship determines the execution of Islamic law on the state level.
Mm-hmm. Yes, I was actually thinking now, because Afghanistan is a topic too, and also in other ILS we find probably we find the issue of being a woman and having the same rights in front of court. So we see, of course, there are ILS where it's normal, of course, also interpret the Islamic sources that there is equality between men and women, but there are also ILS where it's not the case. But let me go now directly on the international level for your book, which is in the specific terms the Islamic peaceful resolution of disputes. And I would like to ask you, because in chapter 4 you write about the theory about this resolution of disputes. What does it say, this theory in general, if you can make it in brief, probably, because
Yes,
it's a long
absolutely.
topic.
Yes. So the theory pretty much says that Islamic law, Islamic concept of dispute resolution is very much favorable towards non-confrontational dispute resolution. Whereas the West embraces courts, embraces the situation that when one has a dispute, we go to court, and there is a dichotomous solution where one party wins, the other one loses. In Islamic legal tradition, the approach is very different, where a mediator is asked to come in and sulh is taking place, whereby the third party, so the mediator, is trying to help the parties reconcile, to become friendly members of Muslim community again. So is this focus on reconciliation, understanding, and forgiveness. That's very different from the Western favor of adjudication, so courts. Therefore, I believe that, and the book tests this predisposition, that Islamic law states should be more favorable towards this idea of reconciliation on the international level.
Okay, so they should probably learn from each other and influence each other for a better peaceful resolution of disputes. Also, you write about al-sulh Sayyid al-Ahkam, and I wonder, because I did not finish it all in detail, but I wrote an article about family disputes in Islam, and there is sulh and tahkim used, where both parties, disputing parties, are choosing one mediator on a higher level, that they talk together. Can we understand this on international level as well? Does it work like this, that you choose just mediators to solve the problem or the issue?
So that's a great question. I love the analogy, because several people have asked me, scholars, well, you know, sulh is something that works at individuals, like you wrote about family matters or personal disputes. How is it that the countries would use it? Really, we need to look at practice of dispute resolution in Islam. We know that a lot of regional disputes between two Islamic law states are usually solved via negotiations, or if the negotiations fail, two Islamic law disputants ask another country to come in, who is also an Islamic law state, to help. And we see it even now in the context of conflict in Sudan, who is trying to help. It's going to be a third Muslim state or organization of Islamic Cooperation or Gulf Cooperation Council. These are going to be powerful leaders or organizations in the region that appreciate the role of this Islamic sulh on the global level. Now, sometimes it's just not going to work. So the book does not say that everybody in Islamic world will always negotiate, always go to mediation. No, sometimes, I mean, it just doesn't work, especially in cases where there are indivisible issues, so where it's hard to settle via mediation. Then they're going to go to court, International Court of Justice, but they will at least try mediation. So excellent question. Thank you for that one.
Okay, thank you. How do ILS view international conflict management methods? So do they favor, I mean, we cannot say, of course, all of them, but what would you say is the tendency to this international conflict management methods?
Yes. Excellent. So again, international law offers a spectrum of methods. First, two countries can negotiate. These are really like you and I are talking, they can solve the problem. But sometimes it just doesn't work. They don't want to talk to each other. They don't like each other. So they're asking a third party to come in. It can be the Pope. It can be the Secretary General of UN. It can be an organization, European Union, OIC. But it's a person or an organ, institution, state that comes in and helps. That's mediation. It can be also conciliation and other third-party non-binding methods. And finally, we have methods that are binding. These are serious methods. These are methods where international law is to be applied. And these are arbitration and adjudication. So adjudication, it's courts, like the International Court of Justice or International Tribunal for the Law of the Sea. These are courts that issue judgments. So when we're thinking about an Islamic law state trying to see what do I want to do, the pattern is that they're going to, again, negotiate first, then usually mediate. And if it does not work, it's going to be serious methods like arbitration and adjudication. But the general trend is that I see this congruence between sulh domestically and preponderance likelihood of Islamic law states seeking out mediation. But again, because Islamic law states are so varied, those that are more secular, they have more secular legal systems, they're going to be acceptant of international courts, more so than I would say traditional Islamic law states with not many secular laws.
Mm-hmm. Okay, thank you for that. I'm interested, you mentioned before the Sudan as an example. I wonder if there are more examples where we can see that in involving Islamic law states. Do we have some more examples than
Yes.
Sudan?
Absolutely. So for instance, the dispute that I specialize in is the dispute between Bahrain and Qatar over Havar Islands and the township of Zubara and a couple of shoals. This dispute erupted very early on. It lasted for many, many years, where Bahrain and Qatar, obviously two Islamic law states that are linked very much physically together, but also via family ties, they just couldn't agree who's this what. And many, many times mediation was attempted by OIC, by the Arab League, by the Kingdom of Saudi Arabia, and other Muslim institutions. But it just couldn't work. It somehow didn't want to work. So eventually Bahrain and Qatar agreed to go to the International Court of Justice and successfully settled that dispute, I believe, in 2001. But we saw an amazing number, really high number of mediation and conciliation attempted, much more so than with an average dispute between two non-ILSs.
I'm very happy that Saudi Arabia and Iran try to normalize their diplomatic relations again. Do you know what kind of methods they use in the international dispute resolution?
So Kingdom of Saudi Arabia usually tries to play a role as a mediator in the region to help to solve disputes in the region. We see that the kingdom sees itself as the bigger brother, bigger sister of other Islamic law states. Now, I would say that vis-a-vis Iran, we see a lot of bilateral negotiations, bilateral meetings. Of course, China agreed here to serve, I wouldn't say as a mediator, this is more of a facilitator. So a state that facilitates conversations, but does not propose solutions, perhaps. Now, we will see. In my opinion, we will see what's going to happen. It's very positive, very much development of normalizing relationship between long-standing, I would say, regional rivals.
You write, I think it was in chapter 6, about the attitudes from Islamic law states toward the International Court of Justice. What kind of attitudes did you find in general? Now, of course, again, it's very diverse, but the trends to recognize, for example, the recognition of International Court of Justice. What do you say about the attitudes?
Number one, there is, in a way, there is some trust in international institutions because, again, countries like Bahrain and Qatar did end up going to the ICJ. It was a very positive solution, but they still hired Western lawyers to represent them at the International Court of Justice. Why is it? Because International Court of Justice, it does represent major legal traditions of the world, but historically, this court has been very much a Western court. I remember speaking to one of the judges at the ICJ, and he says, you know, one time I looked around the bench, and every one of us was from Oxford, Cambridge, or Sorbonne. Rarely do we have a representative from an Islamic law state. Now, I will say that those trends are becoming more favorable for Islamic law states. There is more diversity in the context of legal tradition on the court. But judges usually prefer not to cite the Islamic legal tradition. Where we see Islamic legal tradition mentioned is in the advisory opinions. So when I spoke with representatives from ILS, they would tell me how they view International Court of Justice as somewhat foreign. Perhaps the message that I got that it would make Islamic law states more friendly toward the court if the judges were more aware of the Islamic legal tradition. But that said, Islamic law states do use the court. They do appreciate its function. So again, we don't see this dichotomy that Islamic law is so different from international law. No, those states are friendly towards international institutions. Okay,
thank you so much. I just want to cite another judge, ICJ judge Al-Khaswane, and he said, and you write it in your book, the ICJ is culturally distant to people of the Islamic world. There is no doubt that the ICJ reflects more Western values and more Western interests. I mean, this is what you said just before. I don't want to go again to this question. I would like to two more questions, because in your chapter 7 you write also about the legal schools of Islam, the Madhahib. Which role do they play in peaceful dispute resolution?
So we know that schools of jurisprudence have contributed much, really huge amounts, to how Islamic law states understand international law. This has been a very important contribution, but in modern times, whether or not a country represents a specific school of jurisprudence really does not seem to matter. What matters a lot more is a regional distribution. So Islamic law states, perhaps in Africa, have a different attitude towards international law than Islamic law states in the Gulf region or Asia. So I would say that over time, the role of Islamic school of jurisprudence in this area has decreased. We see more of a convergence between Islamic law and international law, regardless of the schools.
Is that because of CR, as we call the Islamic international law, regulating foreigners' law and also regulations for war, for example? Is it because of CR was developed later after the death of Prophet Muhammad that this does not, the madhab does not play a big role in this kind of dispute resolution on an international level?
I think that over time, the influence has weakened. So it used to be, I would anticipate, a couple of 100 years ago, that the schools of jurisprudence will play a bigger role in understanding. But now the interpretations, the differences really don't seem to matter. I would say that big focus, for instance, in the Gulf would be mediation, much more so than in Africa. And then Asia, Oceania have their own philosophy. So, yes.
Okay, thank you. I want to finally summarize and ask you again, just in short, the key findings now. What would you say are really, again, the key findings of your work? Why should one read your book? And the second question combined to it, because you have it's a big research. It was really did not see such in a long time such big research. So what would be the desiderates of it? Because I'm sure if you research in a topic with international law, Islamic law, ILS, and then dispute resolution, are there desiderates? Where can students follow up maybe in their postdocs and pre-docs affiliations to university? Where can they go take your research and say that's a good basis for deeper research?
Excellent. I love to look forward. So first of all, I think the main findings of my book is, number one, that Islamic legal tradition is a major legal tradition of the world that we should consider in the context of international law. We should consider in international institutions, because what we want, I'm assuming, is cooperation, global cooperation. We don't want conflict. But if we focus on differences and ignore similarities, that's just creating division. Let's focus on similarity. Number two key finding, Islamic law states are diverse. We cannot anticipate that all of them will will exhibit a certain attitude towards international law. They are different, and let's let them be different. Let's don't say that I am sure this Islamic law state will not like International Court of Justice. No, we can't do that. Number three key finding, Islamic law states are friendly towards international law. Granted, there are some differences, some pushbacks, but overall, we cannot say that there is this huge gap that's impossible to bridge between Islamic law and international law. What do I see for the future of this research? I think that the book is a big statement to generate a lot of novel research agendas. For instance, what are the limits of those similarities between Islamic law and international law? What areas did Islamic law contribute most in international law? For instance, I am writing a new book now in how different regions of the world contributed to the development of maritime law, so law of the sea. And Islam has contributed immensely. We just don't know about it because we don't write about it. So focusing on the substantive areas, such as criminal law, human rights law, law of the sea, law of territorial sovereignty, I think getting to the details would be fantastic, and tracing the developments and contributions in each of those areas.
Hopefully we find a lot of motivated students reading your work and start their own research. Thank you so much for this exciting talk, Professor Emilia Justyna Powell. We end this podcast here, and we wish all people around the world peace and prosperity. This is what WMCC is standing for. And for those who are fasting in Ramadan, we wish that Allah will accept your fasting and protect you all. The last word is with you, Emilia. I say thank you for the time and thank you for the talk.
Thank you very much, Michael, and salam to all of my friends. I really appreciate you listening to this conversation.
Thank you.